Hello, everybody. It's Philip Lee returning with another episode of Civil War Chat. And today is the 7th of July. It's a Wednesday, 2021. Just a note to click on the subscribe button below here and to subscribe to the podcast, and also click on the notification bell in the upper right to be notified when each one is released. So what I'd like to do now is to proceed with our commentary for today, which is a law review article on Washington and Lee's alleged racism. Last July, Washington and Lee assistant professor Brandon Hasbrouck published his White Saviors article in an online version of the W&L Law Review to make his case that the school should be renamed by dropping the namesakes. He rejects both George Washington and Robert E. Lee because they were, quote, perpetrators of racial terror, close quote, notwithstanding that Washington founded the country that eventually gave Hasbrouck his freedom of speech, and Lee put the once nearly bankrupt school on sound financial basis, thereby enabling the school to pay Hasbrouck his salary. Now, many assertions in White Saviors warrant examination, and I'll go over a few of them. Foremost among them are claims that Washington College students were involved in 2 attempted lynchings during President Lee's tenure, which was from 1865 to 1870. Hasbrouck's source is an article written by a W&L journalism professor last year, which in turn cited a book by Elizabeth Pryor titled Reading the Man. One incident concerned a white shop owner who catered to blacks. While ice skating on the North River, he pulled a pistol and threatened to shoot a 12-year-old boy who had insulted him. Although an angry crowd chased the shop owner off the river, he suffered no serious injury. After he accused 3 students of being among the crowd, Lee investigated and dismissed 2 of the students, while the 3rd one withdrew. A second alleged attempted lynching involved the shooting of the son of one of the trustees of Washington College, and the son was shot by a black man named Caesar Griffin. After the shooting in downtown Lexington, a group of students hunted and captured Griffin. According to Lee's biographer, Douglas Southall Friedman, quote, some spectators thought they, meaning the students, intended to lynch him, meaning Griffin, but that was not their intention. At General Lee's insistence, they turned the miscreant over to officers of the law, close quote. Griffin was tried in a Virginia court and sentenced to a brief 2-year prison term, partly because the youth had survived the gunshot wound. However, a carpetbag federal judge overruled the state court and released Griffin. In May 1869, however, Supreme Court Chief Justice Salmon Chase, who was then working on the circuit court, as he was Chief Justice, but he was working on the circuit court at the time. Nonetheless, he overrode the carpetbaggers ruling in May 1869. Now, beyond the so-called lynch attempts, Hasbrouck quotes an Associated Press, quote, fact checker, close quote, from a June 12, 2020 article entitled, quote, General Robert E. Lee owned slaves, close quote, to justify Hasbrouck's claim that, quote, he, meaning Lee, was a monster. Black bodies were desecrated and skin mutilated by Lee himself, close quote. But the AP story makes no mention of any of that, no mention of Lee desecrating slave bodies or mutilating their skins. It was mostly about whether or not Lee owned slaves. Nothing about desecrating bodies and mutilating their skins. The professor cites a paper by John McClure to claim that Washington College students sexually assaulted black girls from the Freedmen's Bureau schools. While McClure does make that claim, It should be noted that the Freedmen's Bureau had the authority to intervene in such cases and put the offenders on trial before a military tribunal, since Virginia was under martial law at the time. McClure, however, concedes that, quote, Bureau agents usually mention such incidents in passing and generally did not follow through with investigations or arrests, close quote. Now that merits investigation. Was it because this was simply prostitution that they chose to ignore, or was it something else? But keep in mind this, the agents were typically Northerners with no loyalty to white Virginians. Instead, they were specifically charged by the Freedmen's Bureau with protecting the interests of freedmen. Hasbrouck also claims that 3 years ago, the Ku Klux Klan, if you can believe 3 years ago they're still around. Anyway, Hasbrouck claims that 3 years ago, the Ku Klux Klan left pamphlets on the W&L campus urging that the school retain its name. His source is an October 29, 2018 memo from W&L President William Dudley that does not identify who distributed the flyers. However, 3 days earlier, an article in the Ring Tum Phi student newspaper said that the pamphlets were only, quote, possibly distributed, close quote, by the KKK. Although the printed documents do appear to have been to have originated with a North Carolina Klan chapter, there is no evidence that the KKK distributed them other than Dudley's assertion that the Klan had admitted responsibility for earlier but unspecified similar incidents. The distribution may alternately have been managed by a group of name change advocates who wanted to smear Lee's reputation by associating it with the Klan. Certainly that would have had more impact on the Board of Trustees' decision regarding whether to keep the name or change the name. But there's no proof of either premise, whether it was done by anti-Lee promoters or pro-Lee advocates. Regarding George Washington, the professor asserts that, quote, Washington would have his enslaved blacks whipped for no reason at all. And then he closes the sentence with this phrase, such as walking on his lawn, close quote. That claim has two problems. First, common sense implies that nobody does anything for no reason, much less whip a slave. Hasbrouck's source is an August 25th, 2019 article from the Washington Post in which the reporter quotes an historian who she interviewed. And the historian said that Washington ordered a slave to be whipped for, quote, walking on the lawn, close quote. Or the historian said there was a record of that. Now, the whole thing is lacking explanatory context. Either the historian didn't provide it or the reporter didn't ask for it. Now, the historian may not have known it. But so if you've got an accusation like that without context, people don't do anything for no reason. So we need context here. So lacking explanatory context, the citation should only be used in a scholarly journal like a law review. It should only be used in there with qualification. And the qualification should be noted, hey, this doesn't make sense. We don't have the context. But the professor fails to do that. Second, Hasbrouck's language suggests that walking on the lawn was only one example of Washington whipping slaves for, quote, no reason. But the source, meaning the Washington Post article, provides no other example of Washington whipping slaves for, quote, no reason, or whipping slaves for anything as far as I know. As a teacher of critical race theory, Professor Hasbrouck concludes his article with several so-called anti-racist suggestions for Washington and Lee. One, remove both namesakes from the name of the school. Two, present faculty must confess to having, quote, perpetuated racist thinking and policy making, close quote. Three, He wants the school to commit to transform the student body from 3% black to at least 50%, quote, of color, close quote, over the next 9 years. He also wants the school to pledge to transform the racial constitution of the Board of Trustees, faculty, and administration to at least 50%, quote, of color, close quote, over the next 9 years. Wants the school to adopt critical race theory and similar classes as requirements for all W&L students, not law students, no, all W&L students. And finally, he wants the school to pay reparations to the living descendants of slaves once owned by the school. Now, in addition to the above, I have to confess, I was surprised at the pedestrian quality of the professor's sources, especially considering that his article appeared in the W&L Law Review Journal online. His article has 39 footnotes from 31 sources. 17 of the 31 sources are modern pedestrian magazines and newspapers such as Roanoke Times, Richmond's Times-Dispatch, Associated Press, Washington Post, New York Times, Atlantic Magazine, and Nation Magazine. Aside from his own, Professor Hasbrouck cites only 3 law review articles. Okay, so that's what I want to say about that article. But one of the key things that if this critical race theory and anti-racism agenda gains purchase more than it has in the academy, you can kiss goodbye all Confederate iconography in a lot of Southern culture. It's just going to be gone. One of the things that I think will help is to look at the reasons for the Civil War, because what these critical race theorists do is they say, oh, the South seceded over slavery, so that was the reason for the war. That may have been the reason why most of the 7 cotton states seceded, but it wasn't the reason for the war, because there didn't have to be a war. The North could have let those 7 cotton states leave on their own. And in fact, there were a number of prominent Republican leaders who thought that was the right approach. That's what this book tells you. Causes of the Civil War by Philip Lee. I published it last October. We got it out last October. It's one of the few books that really looks at the reasons why both the North and the South went to war. Instead of just saying, oh, well, the South seceded over slavery, so that means the war was over slavery. No, you kind of look at, why did the North not just let them go? I mean, for many years, the abolitionists claimed they wanted the South to leave. They didn't want a union with slaveholders, they said. So you got to literally look at, why did the North choose to fight? That's what this book tells you. And if we can get that education into the academy, then, critical race theorists are not going to just say, well, the South was all about perpetuating slavery. So, half of the white population of the 11-state Confederacy was in Virginia, Tennessee, North Carolina, and Arkansas. They did not secede until Lincoln put out a call for 75,000 troops to coerce the other 7 cotton states back into the Union. They would have remained in the Union. That's what they intended. They did not secede until they were forced to contribute. They were asked to contribute troops to coerce the 7 cotton states back in the Union. And back at that time, the coercion was considered unconstitutional, certainly by all of the Southern observers, or nearly all of the Southern observers, and many of the Northern observers. There's many cases, and I cover them in this book, when Northerners wanted to secede. I won't go into that now, but if you want to get a copy of this book, just go to Amazon or Barnes & Noble. It's $22 there. You can get a copy of it. You can get a Kindle version even less, and I also have an audio version. But if you want an autograph copy, then contact me, Phil, P-H-I-L _Lee, L-E-I-G-H @me.com. Okay, that's our show for today, and thanks for watching.